Now, so welcome back. I hope you all had a nice, energizing lunch. So I'm really excited to start this afternoon session, which is a bit of the innovative side of this conference, or at least we tried. So with this interactive session, we welcome submissions from junior scholars, and you can see the first one here. Pier Giorgio will be talking today about disentangling encryption, but I will get there in a second. And so the idea is that we selected 3 junior researchers and we paired them with senior researchers who then have reviewed their papers. So how this session works is that the junior researcher, so in this case Pier Giorgio, will begin by presenting the paper, and after that the senior researcher, in this case Michael, will be building upon it, reacting, giving feedback, really up to you, as this is a new format, whatever you think it's more interesting for the audience and for you as well. And after this, we also have the opportunity to have an open discussion on the paper between you two, so the senior and junior, but also, of course, we welcome questions from the audience or any comment, as we have done earlier in the panel discussion. At the end of these 3 tandem sessions, the 3 senior researchers will join a panel to discuss more in general future developments in academia and try to offer some guidance to young researchers in the field of data protection, but also IT law in general. So I would like to start, let's say, the first junior-senior tandem session, introducing Pier Giorgio Chiara, who is a doctoral researcher in law, science and technology, joint doctorate, rights of Internet of Everything. And his doctoral research focuses on the security and privacy of resource-constrained devices. But today he will be talking about his paper with the title Disentangling Encryption from the Personalisation Debate, a modest reflection on the relativist approach underpinning the identifiability criterion. So the floor is yours. If you want to share the screen, you have the rights to do so.
Thank you, Catherine, for the kind introduction. I try now to share the screen. Okay, so now you should be able to see the presentation, right?
Yeah, we can see the presentation.
Okay, perfect. So, yes, hi everyone. Thank you for having me. My paper has been introduced by Catherine, is titled Disentangling Encryption from the Personalisation Debate. So, having regard to the content of this presentation, without dwelling too extensively on the typology classifying encryption, pseudonymization, and hash functions, I will briefly cast the light on the 3 possible understandings of Recital 26 of the GDPR in order to legally qualify encrypted data. Then I will investigate how polymorphic encryption, two-way function, so to speak, may raise an argument for the revival of the relativist approach within a risk-based understanding of Recital 26. Then I will briefly sketch some conclusive remarks. So the great confusion around encryption, a cornerstone concept of data security, may jeopardize a proper taxonomy in order to legally qualify data. This paper aims precisely to ascertain whether and to what extent state-of-the-art cryptography may challenge the distinction, albeit increasingly blurred, between personal and non-personal data. The legal analysis then focuses on 3 possible readings of Recital 26. They actually have been well outlined this morning already, but then. So from a methodological viewpoint, this study takes advantage of Floridi's method of levels of abstraction. The research question sets the level of abstraction, namely the classification of encrypted data from a data protection viewpoint. Having set the context, the so-called level of abstraction can be grasped as a model or interface made up by 3 different observables that are the features of the legal analysis. The first one is a technical taxonomy of cryptography, encryption, and pseudonymization. With the second one are the different understandings of Recital 26, and the third one is our case study. So encryption is traditionally deemed as a two-way function. What is encrypted via the cipher algorithm can be decrypted with a proper key. Cryptographic hash functions instead are commonly referred to as a one-way function, namely typically irreversible process aiming at scrambling variable size plain text to produce a unique fixed size message digest, message plain text. Pseudonymization, finally, could be seen as a means of reducing risk to data subjects by hiding the identity of individuals in a dataset. It falls within the scope of GDPR, as clearly explicit by the regulation. So Recital 26, as we already saw this morning, sets the scope of the regulation by stating that data protection principles should apply to either any information concerning an identified or identifiable person, thus person to this recipe. The identifiable tenet shall encompass all objective factors, such as cost, time, and available technology. First possible reading envisage all the possibilities, the absolutist one, envisage all the possibilities in which anyone would be able to identify the data subject. Article 29 Working Party, by endorsing this reading, seems to establish its own zero-risk test, as outlined by the work of Fink and Pallas. Encryption-wise, if anyone is theoretically be able to decrypt the dataset, then the operation of the controller or the processor would fall within data protection scope, even if the controller, for example, do not possess the decryption keys. A second possible approach, consider only the relativist approach, consider only the role of data controller and her efforts in establishing a link between a person and the related data. Encrypted data, according to this understanding, should not be considered personal data if cryptographic tools are solid, but also if data controller neither possesses the decryption key nor have reasonable chances to obtain it. Finally, Recital 26 shall embrace a risk-based approach to assess the personal nature of data. If the personalization has been strong enough so that identification is no longer reasonably likely, GDPR wouldn't enter into play. As demonstrated by Fink and Pallas, by using salted and peppered hash function, GDPR's intensive, to some extent, non-scalable regime could be eschewed, since the effort needed for the re-identification are not reasonably likely. So, provided that one-way up-to-date encryption, like salted hash function via the algorithm SHA-3, shall be considered non-personal data, according to the recent work of Fink and Pallas, what about two-way encryption? Is that tout court meant to be personal data? I will consider the case of polymorphic encryption framework, a methodology published 4 years ago by Veale and others, such as Jacobs, Meyer, and Hildebrand. The case of polymorphic encryption, which is indisputably a two-way function, namely reversible, may be a case in point, since the core concept is to put the data subject at the heart of the encryption's operational and decision-making process. The assumption is that traditional asymmetric encryption or public key encryption is too rigid. There is only one key able to decipher the information encrypted. This technology enables strong encryption at the source, thus ensuring that either transport or cloud facilities storage occurs to data which have been already encrypted. This is a game changer. Polymorphic encryption works in a generic manner, and the decision about who can decrypt do not need to be taken at the time of encryption. It follows, therefore, that no data management staff, hosting partner, or cloud service provider has the ability to access and decrypt the data, ideally. For each data subject, it should be assumed that there is a private master key, say X, securely stored by a trusted key server in a secure hardware that it's never used for decryption. So the data subject plays a crucial role, as we stressed, in deciding who can decrypt her data. Anyone chosen for decrypting personal or sensitive data will be given a unique private key derived from the one and only private master key, X. Afterwards, an intermediate party called, in the methodology, the tweaker, grants access to the chosen parties by rekeying messages encrypted via the public master key. The tweaker is a central converter who exclusively knows how to turn the wheel on a metaphorical polymorphic lock so that keys of specific parties fit, and only those keys. It is however crucial noting that the tweaker works blindly. It does not know X, and it cannot see the actual content of the information she is giving the access for. So the assumption here is that polymorphic encryption explicitly recalls the relativist understanding of the recital at stake, since the perspective from which identifiability should be assessed is that of data controller, precisely because until the tweaker grants her access, neither she nor any other third party can decrypt data encrypted at the source. The application protocols of these cryptographic means are by their essence relative, since ciphertext and possibly sensitive personal data is disclosed upon data subject choice to specific and trusted parties. These encrypted data should be considered therefore non-personal to anyone who does not have access to them, namely the key server, the tweaker, the cloud service provider, and ideally any other third party without the access or the key to decrypt the dataset. Assuming that it is not a zero-sum game, one can possibly apply the risk-based understanding within the relativist approach. It has to be analyzed, therefore, to what extent the PEP framework, namely the polymorphic encryption pseudonymization framework, security assumption can be deemed solid enough so that identification is reasonably unlikely, but for the chosen parties who can decrypt the data. In the words of Pallas, we have to do the math. The further reflection in the paper that needs to be done revolves around the concept of trust. The security of the system rests inevitably on having two separate trusted parties, one holding the master private key and one transformer, the tweaker. If these two trusted parties collude, then the system breaks down. So if it were to follow the reasoning of the European Court of Justice in the Breyer case, identification would not be reasonably likely if achieved by means prohibited by the law, which is actually the case of collusion. However, as Putrova pointed out in a paper on the law of everything, since re-identification results indeed from illegal acts, more nuanced reasoning would be that a legal prohibition to combine data for identification would make the means of identification less reasonably likely to be used rather than not at all. So in order to increase trust by avoiding potential collusion, a decentralized rekeying scheme could be considered. Through the adoption of several security protocols, such as Shamir secret sharing, data subject gets total control over the generation and management of the decryption keys without relying on a trusted authority. If two or more parties, such as in the case of cloud service providers, combine the keys, they could not decrypt data. Secret sharing algorithms can be successfully applied either to distribute the encryption key among a number of cloud nodes, say, or to divide data subjects' encrypted data into shares to be stored subsequently in different cloud service providers. So coming now to the conclusion of this presentation, the risk-based approach, as outlined by the recent work of Fink and Pallas, and opposed to the absolutist understanding of Recital 26, should be recognized as the correct interpretative key for the reading of the Recital. Yet, an attempt has been made to illustrate how the case of polymorphic encryption, in this case, a two-way function, can be a solid argument for the revival of a debate on the relativist approach in a complementary perspective, vis-a-vis the risk-based one. Those data, encrypted with specific two-way functions such as PEP framework, shall be considered non-personal to all those who are denied the possibility of decryption. And by putting data subject at the very center of operational decision in the context of data cryptography, controls paradigm would be rebalanced towards data subject side, albeit data controller would, of course, remain accountable for the processing. So that's it. Thank you for the kind attention, and I'm looking forward to hear your comments and questions.
Great.
Thank you, Pier Giorgio. Thank you very much. I will just briefly introduce Michael Veale. Many of you might know him already. He's a lecturer in digital rights and regulations at UCL Faculty of Laws. His research sits at the intersections of emerging digital technologies, internet and data law, technology policy, and human-computer interaction. Among many other areas, his research also focuses on the legal tensions caused by encrypted data analysis and the business side of privacy-enhancing technologies. So the floor is yours to react to Pier Giorgio's presentation and paper.
Thank you very much. I'm going to share my screen as well here and just run through some reflections and to stimulate some thoughts. So thank you very much for the paper, Pier Giorgio. I think it was really interesting, and I think there's a lot in it we can talk about and discuss. And I know that some people have just joined, I think, in the middle of the conversation, so maybe this slide will be a bit helpful to help those people. So while I'm not going to rehash what has just been said, one thing that I think is interesting is to discuss the polymorphic encryption aspect of this paper. So the central idea of polymorphic encryption is a technically enforced access control scheme, effectively, that allows many individuals to have access, but with the cloud provider being unable to have access themselves. And it's useful for me just to discuss the framework before we can discuss some of the legal aspects of it and some of the observations that Pier Giorgio made in his paper. The cloud service C has a data set encrypted in a way that they can't access it. And an actor U, who we would like to have data access, also has a right to delegate access to their portion of data to someone else. So more keys can be provided so that other people can access data in cloud service C. There's a trusted third party, that's P, and they have a master key of sorts. Effectively, any attempt to create more keys for the data set has to go through them, and the data access is mediated through their ability to say, yes, this person should have access to this data, this person should have access through a key that they have, an identifier that they present. There's a bit more in relation to passing on identifiers and back and forth of people in the data set, but we don't need to go into that. An important aspect is there's a non-collusion assumption with the cloud service. So we assume this organization holding the master key does not collude with the cloud service, because if they did, anybody could access all of the data in the system. Effectively, this actor can ask, an actor like a data subject can ask a third party P to produce an extra key for their data, and that third party interacts with the cloud service to re-encrypt the data in such a way that it also now works with this additional key. And it's a bit more complicated than that. There are, the actual system has more functions than this if you look at the papers that underlie it. But this, I think, gives a flavor of what we're talking about here. So with that observation and that broad structure, how does it interact with the notion of data protection law and personal data? So I think a question that was not really raised so much in the paper by Pier Giorgio was exactly who this is no longer personal data for, which constellation of actors. So, for example, if we take the example of medical research, which this system is designed for in mind with researchers at, it's a collaboration between Radboud University and Google, this system. So the medical research, in this case, different keys to this data are provided to every different researcher involved in this data so they can get a copy of the data without the cloud service that's maybe storing it for everybody's convenience being able to see the data in this sense. But let's think about what Cloud Service C would be in terms of data protection law. Well, they're initially a candidate in normal times to be a data processor. They're not a candidate for being a data controller. We might think of them as AWS or Azure, and a data processor, as the audience will likely know, is an organization that takes instructions from the data controller and has lesser legal obligations than a data controller would do. They are mostly doing the bidding, and of course they have to uphold security of the data, and they have to act on the instructions of the data controller with respect to the data inside, the data rights, for example. But they already have lower obligations anyway. And who's the controller in this situation? Well, it's not really so clear, because it could be the data subject. There's an increasing thread of work that says data subjects can be data controllers, and Michelle Fink and I and others wrote a bit about that recently, and some other people have as well. And that's a bit of a legal strategy for some organizations, but it might also be a sort of overarching entity. We might think there's controllership responsibilities in that trusted third party who's giving out the keys. It depends on exactly how the situation is organized. But whoever it is, there has to be a data controller. And if there was going to be a data processor, they would have to be contracting explicitly with that entity, that cloud service. So the irony of the model that we're seeing, the polymorphic encryption model, is it's completely preoccupied with an inquisitive cloud service provider as the threat model. And when we think about to what extent is this or is this not personal data, we are only thinking, can we make this not personal data for the cloud provider who would usually be a data processor? That to me seems to be the overarching motivation behind this. And there may be reasons to do this. We can think of the logic in Schrems 2 to avoid data being sent overseas outside the jurisdiction. We might want it not to be personal data so that the data protection law doesn't apply, and we can then reliably not have to rely on Privacy Shield or standard contractual clauses. So that might be one reason. But the problem we have here is that in general, other than those quite niche areas, and we could talk about international data transfers, that's cool, but other than those areas, what we're doing here with polymorphic encryption is attempting to lessen the legal obligations of the cloud provider. We're attempting to take away rights and obligations from them. And that's the main effect of rendering this non-personal data, because it doesn't render it non-personal data from anyone who has the key. And anyone who has the key has access to the clear text of data, and is, of course, that doesn't change the logic of personal data in relation to them. Why might this be problematic? Well, it's problematic because we also care not just about confidentiality of data in data protection law, but we also care about availability of data and integrity of data, which are both parts of the CIA triad of data security. And of course, we care about fairness and many other things too, and that are accountability that are in the data protection principles. And the problem with this, looking at availability and integrity, for example, and linking that, for example, to the accuracy principle in the GDPR, is that if we consider this former data processor now not to be a data processor because they're not holding personal data, therefore the GDPR doesn't apply, then they have no obligation to keep this data secure from a point of view of integrity or availability. I could inject false data into it. I could remove particular records. I could redact records that came from a certain day or time. And those are also things that data protection law is designed to protect. So looking at it from that kind of purposive point of view of what we're trying to achieve with attempting to argue that data protection law is removed by polymorphic encryption, we also remove a lot of obligations that we might like data processors to have. And I know principles apply in different ways to data processors, but I'm talking in general terms here. I think there may be some people who are sort of thinking about some of the textual links in the GDPR, but I'm still talking in broad terms around data protection, or maybe in general rather than just in our European iteration right now. We also don't consider so much the systemic issues. In the paper, it considers absolutist, risk-based, and relativist approaches. But data protection has also had its origin in creating a trustworthy digital society. And the idea of polymorphic encryption is that you can generate more and more keys and give them out to more and more people. And once you generate a key, you can't go back. Effectively, someone could have downloaded that encrypted data set and it's available in the world, and you might not think it's personal data, but if you generate a key for it after it's been rekeyed, the data, then those two pieces of information exist in the world, and no attempt to rekey that personal data now afterwards and redact or revoke that key will remove the fact that that encrypted data set on the formerly rekeyed set of data now exists. So we can think about also the increasing number of keys and access control does create systemic risks, like you might do when you leave files on a train seat when you're in a train. So we have to think about some more systemic problems, and those are also reasons for a risk-based and an absolutist approach, because you have to acknowledge the reality that data is leaking all the time, and who can access that data is changing over time and has changed over time in the past. I also want to ask where this concerning ballooning of personal data is happening, and this is the kind of ballooning that is mentioned by, for example, Nadia Petova, who I think is on the call as well, and was mentioned as well in Pier Giorgio's paper. And so I talked a bit about the processor idea, but the problem with the ballooning of personal data is not really that we have processors in the world who can access, who have data that is clearly personal. I'm not sure that's what we're talking about. I think there's a bit of a category error going on here with what we're discussing. The ballooning of personal data relates to not the idea that in a single data processing operation, many more actors have obligations relating to that personal data than maybe they should do. I think the issue comes with data sets that we might not want to consider personal data, or some people want to not consider personal data, are being considered personal data by the expansive definitions in Recital 26. That's not solved by polymorphic encryption at all, because polymorphic encryption is very clear that in this crypto system, personal data does exist at certain points and is produced at certain points and is accessed and analyzed. So it doesn't reduce the scope of personal data, it just changes the actors that have evolved. And that's why I think it's best understood as an access control scheme. And indeed, there are further reasons for concern with this focus on reducing the number of actors or removing legal obligations for them. And finding new ways to exempt intermediaries, like hosting intermediaries such as Amazon Web Services or Azure, from personal data obligations, because it actually allows them to process data, not personal data in this case. If you don't want it to be personal data, it allows them to process data for their own ends, rather than just at the demands of the controller. And so what do I mean by this? Because if it's encrypted, surely it's fine. Like, they can't process it for their own ends because their hands are bound. They haven't got anything to process. Well, that's not quite true. This is the dream world of large corporations. And I've got a bit of a fake quote I made up here, because fake quotes are always the best way to justify things in legal scholarship. This is a big corporation saying that they want it to be that none of the individual data sets I process are considered to be personal data, but I can manipulate them to create knowledge for my own ends, which is non-personal data, and to render the world more legible at a group level or at a higher societal level. So I can effectively have my cake and eat it. I can get knowledge about the world without ever having seen any personal data in the process. Then I get no liability, no restrictions, and I get all the informational power. This is, I think, the dream world of large corporations, and I want to just give you a very quick overview as to why this could be true before we open up for discussion and I get some responses from Pierre. We see, I'm going to just give one example of one technology here, multi-party computation. Many emerging crypto systems are purely designed to to allow operations on encrypted data without the organizations orchestrating those operations ever seeing personal data at all, like Odysseus binding their hands, unable to see personal data, but getting through the sirens. So a secure multi-party computation protocol effectively allows many individuals to collectively compute an aggregate function, which might be, it could be aggregate, doesn't have to be, but it could be an aggregate function which we might consider not to be personal data, over data that is sharded or spread among many people. The organization doing the computing wouldn't see any personal data in this process if they designed it correctly. They might be training a machine learning classifier. They might be trying to discover an aggregate fact about the world. We see this, companies are investing more and more in these technologies to try and avoid personal data obligations when they're in this process. So we see multi-party computation can work in many ways. The traditional example on the right has lots of phones all holding your own data about yourself, and they basically send gobbledygook to each other. They send encrypted messages that mean nothing to anyone else, but out in the middle pops the aggregate function after the end of this. But there's also maybe more linked to what Pier Giorgio was talking about here, the idea that multiple servers can work together, and we assume they don't collude to repiece this data together. But out the end, similarly, pops an aggregate function, despite all of this data being considered to be encrypted and no one being identifiable from this data. This is the dream, and what does it result in? Well, we can see it happening today. Google and MasterCard, for example, want to try and link their large data sets together. This is a real example. Google knows they basically want to work out if somebody who saw an advert or clicked on it actually went to purchase a product in the end. Google knows who saw an advert and which advert they viewed, and MasterCard knows who bought a product and how much they spent. Can you combine these data sets together and get aggregate results on a per ad campaign basis? So not personal data at this point. This is relating to the amount of money that a single campaign brought in, not by person. Can you combine these data sets and pop out this end result without ever seeing the personal data of the other party? Short answer, they argue yes. They use something called private set intersection based on homomorphic encryption. The input being two parties with personal data and shared identifiers, and the output being aggregate non-personal data of the spend of those who saw ads, the total spend of those individuals. The next step for them is to actually get rid of this personal data from the process by encrypting or distancing themselves from it. For example, by putting this data onto a browser or a user's end device, and Google and MasterCard never having access to it, but Google and MasterCard having access to this end result. That's their dream of reducing liability, which is the kind of logic, I think, more broadly, that Pier Giorgio lays out in his paper. Not explicitly, but I think it's the logic that this paper could be dangerously used towards. Similarly, we see targeting happening at local level on people's phones. The idea, can we do detailed micro-targeting on an individual's phone, but without data ever leaving their devices? And I don't want to kind of go through this, but the answer is basically yes. Browsers like Brave are doing this. There's a huge investment by Facebook, Google into poaching all the people who have the expertise to do this. Google have a thing called Privacy Sandbox, and Flock, federated learning of cohorts, trying to do this system right now. And this is exacerbated by the walled gardens. So in Pier Giorgio's example, you have this trusted third party, and the user has the power to choose to go to them, to choose to ask them questions, to choose to have this new key made. What we see in the real world is not like this at all. We see that we don't have access to the code that's running on our devices. You can have third parties everywhere, but individuals aren't empowered to choose which calls or programming calls their devices make within these walled gardens. And so the idea that we have the freedom to choose how our protocols run for our own security and autonomy is not true. And we're in danger of missing that if we look at the mathematical assumptions behind privacy enhancing technologies alone. So I want to end up and say that encryption is done for a purpose. And I think when we write papers around this, we can't just talk about hashing or one-way functions or two-way functions. We have to understand the processing purpose, and we have to understand what people are trying to achieve with this. Is it singling out, for example? Is it targeting? And we do need to look a bit more broadly. And it does require us, when we think about what is personal data, we may need to bring in what is the purpose of processing. because otherwise, if we work in a very technocratic way forward from the idea of personal data, we can end up at some very, very perverse places, which are not very protective under the fundamental right of data protection. So what are the lessons? We need to examine very closely what problem we're actually trying to solve by making personal data a narrower concept in certain areas. And we need to do that in the context of business trends, desires, business models, societal power. It's not a slider when we alter the personal data definition. It moves responsibilities around and it allows regulatory arbitrage. So we have to make sure we are aware of that. Definitional changes need to be seen in terms of these wider changes to encryption and computing possibilities like multi-party computation and the desires to operate over encrypted data, because they can have unintended side effects if we move this data definition with a narrow case study like research or medical research. And lastly, data protection isn't just about confidentiality and encryption. It's also about fairness, accountability, and accuracy and integrity, lots of other things. Computer science often falls into this confidentiality trap alone, thinking that's what we're trying to solve when we solve data protection. And data protection is not something to be solved. It's something to be managed and thought about more broadly. So thank you very, very much for the paper. I hope that was a useful response. And I'd love to hear Pier Giorgio's thoughts in response to that. And also please open up for questions and I can moderate and take some questions from the floor too. And we can put them together between us.
Yes, thank you. Thank you for the insightful comment on my article. So first things first, yes, I acknowledge the weakness, the major weakness of the paper could be like rendering this ideal big techno companies escape from data protection regime and data protection safeguards. The rationale of the paper was actually the same of GDPR, the regulation itself, namely try to have at the core of the debate guarantees aiming at protecting individuals' fundamental rights and freedoms. I really enjoyed the example of Google and MasterCard. I do think that I still have to do a lot of research in the interdisciplinary field, so to speak. Since insight from, let's say, computer science models could be useful to grasp how actually the reality is going on, rather than remaining, let's say, more on an abstract layer. So yes, again, thank you. I written a lot actually, and I think that I would have to make more clear actually the point of the rationale, the core of the paper, namely not to loosen that much data protection legal safeguards, rather try to enforce data subjects control over. Control maybe is more appropriate in this case. Management over their own data. I don't know whether there are some comments or questions in the chat.
We have a question from Frank, and you're welcome to ask it in person, Frank. Maybe the idea, yeah, I don't know how to do that actually, so I'm not sure that's really possible. But Frank says, given the actual practices and givens in cloud computing, might it be more suitable for joint controllership than a pure processor model? And how would this change the arguments that you think? I mean, so I want, I guess, kind of to reframe that as well. Under what conditions who in your envisaged view of this might be a candidate for being a joint controller, and under what conditions?
Well, I do think that the case of a cloud service provider, especially from a pure relativist approach, could be a good case for establishing a joint controllership in such scenarios. I mean, it could depend on whether the cloud service, as probably in the case of Google and MasterCard you mentioned before, is trying to determine the process actually. And by that I mean using the data, even though encrypted, even though, so to speak, non-personal, in a way that it could determine, or a profit actually from such data. So probably in the case of again Google, MasterCard, cloud service, a joint controllership rather than envisage them as pure processor could be more compliant to GDPR. But still, I still have to figure it out more deepen.
Great, and I think Frank's followed up and noted that AWS, determines means themselves. I think that's a really interesting point, Frank. We often, not only are they using metadata to understand cybersecurity and to improve security themselves, and metadata is really important around that, but they're using a whole variety of data they understand from the running of their virtual machines, and decide about means because, not just because they are using data to improve their systems based on how people are running. And you can see that in Chris Millard's book, Cloud Computing Law. I think a new version is coming out soon that's really useful for that. But also, we can think about the design structure of cloud services and APIs as inherently restricting the means and determining what people can and cannot do with cloud services. And that's an interesting question, I think, about the way that protocols influence means even when they're preset, and they reduce the selection of things that can be done with data, and to what extent data protection law needs to think more about structural and architectural limits as inducing controllership. An anonymous attendee, a mysterious anonymous attendee, has asked effectively that given encryption is really funded by Apple and Google, who want to use data analytics while complying with data protection principles, what should we do with such big tech companies to suppress their informational power? I've got thoughts on that, but I'd love to hear Pierre's thoughts in particular.
Yes, this is a very interesting question, as the other actually by Frank Pallas, I have to say. So, I mean, I think that the case is explained by you, Michael, in context, again, of Google and MasterCard, is a case in point because they actually works on aggregated data, which should arguably be deemed as non-personal, and nonetheless, their informational power is not suppressed at all. So I think that these economy models benefit a lot, even with non-personal data, and it's a thing. Therefore, I don't see actually how the GDPR compliant could really lose the benefit of data analytics vis-a-vis this giant of data economy. But this is my 2 cents on that.
Personally, I think that we have to think about interoperability and allowing people to decide what protocols are running on their own devices, because if we don't see data protection in combination with the walled gardens of code running on devices, we end up sleepwalking into a different kind of trap. And I think that links to the Digital Services Act and links to other tech policy areas. Lastly, because I know we started a little bit late, but I don't want to overrun in time. From David Bierbauer, he notes that in multi-party computation, the broad definition of processing still applies, so it's hard to see how data protection is avoided. My view on that is simply that I think you're both right and wrong there. I think it's tough because processing refers to the existence of personal data, and personal data is itself contextual on its personal data to one person, but not another person. And so I think multi-party computation creates a problem of multi-party computation creates a problem of for whom is this processing, for whom is this personal data, and who is responsible, who could be a controller, and who actually has the ability to enforce data subject rights because they can see or operate on clear text data. I think it throws a spanner in the works. It doesn't neatly avoid data protection. I think it just shows a lot of tensions in the law that are not dealt with in the text because the text did not anticipate processing without seeing personal data, for example, like that kind of thing. Or without being the same person who can see it. I think that's a challenge.
Yeah, I actually agree. I mean, also the anonymization process is to some extent processing. So processing could be quite tricky because it can, be extended to almost all the operation we do in the digital environment. So.
Great. So I think we're going to leave it there so we're back in, keep everyone on time. Thank you very much for all of the questions, and thank you very much to Pier Giorgio for your really interesting and fantastic paper. Thank you very much, and
thank you too.
Great. Thanks everyone.
Thank you. Thank you very much. So in case if there are further points on this part of the session, we can also address it in the panel discussion. Pier Giorgio as well, if you want to get involved in the panel discussion, you're very welcome, of course. So I will make you attendees again, and we can move on to the second tandem session, which